Ladies and gentlemen, today I have a very interesting discussion in light of a legal paradox of Uganda's reserve forces, particularly in light of Dr. KIIZA Besigye. Whether or not Dr. KIIZA Besigye is caught between a hard rock and a hard place. And the inference I'm making is in light of some ideology that was proponent to me by Professor Ben Tinongisha, which brought food to my thought. The legal status of military personnel in Uganda presents a unique paradox, blending elements of both civilian and military obligations, particularly under Section 42, subsection 1 of the UPDF Act. And ideally, best a soldier who perhaps retires or is discharged from active service is automatically registered into the reserve force, making them subject to recall for military duty in times of war or even national emergency. And this dual status raises concerns, legal, constitutional concerns in terms of policy questions about the extent and the state of control over retired, personnel in light whether or not they're civilians or whether they still comply with international and human rights obligations. And the point I want to raise here is at the heart of its legal dilemma lies the fundamental tension that can actually a retired soldier like Dr. KIIZA be considered a civilian while simultaneously remaining bound by military obligations. And jurisprudence in this issue, including Uganda versus Lieutenant Colonel retired Samson Monday, suggests that while retired officers are generally, classified as civilians, they retain residual military obligations. However, this interpretation is not without controversy, and it raises constitutional challenges regarding individual freedoms in light of forced service and the principle of voluntary associations under Article 29E of the Constitution, 29E1 of the Constitution. So beyond obviously domestic law, another aspect is that Uganda's compulsory reserve enlistment model also stands at odds with the international obligations under treaties such as the International Covenant on Civil and Political Rights, the ICCPR, and the African Charter on Human and People's Rights, the ICHPR, and the East African Community, ESC Treaty. So these instruments emphasize voluntary military service in light of freedom from forced labor and protection against arbitrary state control in light of principles that Uganda reserve force systems arguably infringes upon. My name is Isaac Christopher Lubogo, and I will delve into a deep analytical and critical examination of the efficacy in terms of the legality and policy implications in terms of Uganda's automatic reserve enlistment framework. And by exploring this constitutional jurisprudence, I will try to decipher in terms of relevant Uganda case law and comparative international standards, assessing whether Section 42 subsection 1 of the Act is actually justifiable, legally sound, and even aligned with Uganda's broader human rights obligations. Ultimately, I will try to seek or provide a comprehensive evaluation of the reserve forces system strength in terms of the weaknesses and also the urgent need for legal and policy frameworks to strike a balance between national security and individual freedoms in a democratic society. In light of what I intend to discuss, I will also create or try to argue in light of a critical examination of the efficaciousness of the reserve force systems under the Ugandan law. And the reason I will do that is to argue in light of the legal status of retired military personnel in Uganda, particularly their automatic membership in reserve forces under Section 42, subsection 1 of the UPDF Act, okay? And raising intricate jurisprudential questions in light of the effectiveness of these provisions that must be assessed in light of constitutional principles in terms of Uganda international obligations, in terms of relevant jurisprudence, and then in terms of comparative legal perspectives. And perhaps this is food for thought. I am inspired by my professors, Professor Oloka Onyango, Professor Dr. Honoria Henry, Dr. Kabumba, who have inspired me a lot in light of jurisprudence. And the faults are mine. The credit is theirs. So I'll argue in light of some of the things that I've told us. So the legal framework in terms of the rationale for reserve forces, first of all, in light of membership, in as far as the reserve forces is concerned, if you look at section 42 subsection 1 of the PDF Act, or UPDF Act, it says that, for example, every person who has actually served in the defense forces has, been discharged or retired shall actually be deemed to be a member of the reserve force. So let's not escape away from that. That fundamentally is important. And we're going to raise quite substantive legal issues in light of that particular dispensation, if you like. This provision basically implies that all retired personnel, regardless of the manner of their discharge, retain a latent military status. Yeah? And the rationale behind this is rooted in national security considerations, ensuring that Uganda maintains a pool of trained personnel available for recall in times of emergency. However, this blanket clarification raises constitutional and human rights concerns, particularly regarding the freedom of occupation and association. I'll cite some relevant case laws that are played out in the event. Okay? Now, also particularly important, I'll probably want to argue in light of what they call civilian status of retired military personnel. And that perhaps, augurs well with the likes of retired Dr. KIIZA BESIGYE. I have to use that word, retired. I used to ask myself why these guys keep referring to themselves as retired. They have a reason. I think it's a legal basis. So the Ugandan law obviously does not explicitly split retired soldiers of their civilian status. However, their residual military obligation place them in what they call a hybrid legal position, which can lead to ambiguity, particularly in matters of jurisdiction, discipline, and even legal responsibility. And let's look at a case, for example, the case of Uganda versus Lieutenant Colonel retired Samson Mande, a case that was unreported, which provides critical judicial interpretation in this regard. And that is something that we're borrowing heavily from in light of what we're trying to discuss today. Yes? If we look at jurisprudence and case law analysis, in light of Uganda versus Lieutenant Colonel retired Samson Mande, I have a brother of mine who keeps referring to himself as retired. I remember when we invited, it must have been a retired Major General Mugisha Moto. He emphasized retired. I didn't know, but now I begin to understand. So in this case, the High Court of Uganda held that a retired military officer maintains subject to military law only in respect to offenses committed while in active service. Yeah? So this judgment suggests that limited post-retirement military obligations are reinforcing the notion that retired soldiers should primarily be considered civilians. Yes, welcome to the debate on whether or not Dr. KIIZA BESIGYE is caught between a hard place and the rock. However, this ruling leaves several questions unanswered, and these are the things that I would like to, to decipher. Can retired soldiers, for example, be tried under court-martial in terms of jurisdictions for offenses committed while in reserve status? Yes, the paramount or the operative word here is in terms of reserve status, because we have all established that they are under reserve status of sorts. Okay. Does membership, for example, in the reserve forces impose restrictions on their constitutional rights? Yeah, that is something, again, you have to comprehend and look at extensively. Yes? And then the other question is, what are the consequences of refusal to respond, for example, to a recall order? Yes, if that, occasions them. And in terms of comparative analysis with Article, for example, 287 of the 1995 Constitution, which suggests that military obligations should not extend indefinitely beyond active service, as doing so would actually infringe on the individual's right to private life and employment. Are we together? I don't want to lose you. I want us to move piece by piece. Let's look at the case of Mukasa versus Attorney General, Constitutional Petition number 6 of 2016, 13 rather. Yeah? In Mukasa's case, for example, the Constitutional Court of Uganda reaffirmed that the military must operate with constitutional confines. Yes? The law that compels continuous service without explicit consent post-retirement could be challenged on grounds of violation under Article 25, Sub-Article 2 of the Constitution, which prohibits forced labor. Are we together? I didn't want to use that phrase, tulifena. I have a friend who keeps saying tulifena, you know. But the point is that the question that arises, therefore, is whether automatic placement in reserve forces constitutes an enforceable duty or a mere designation. If the former, it could actually be deemed unconstitutional unless accompanied by an opt-out provision. Not so. And that is something you must comprehend again from the word go. Yes? Now, let's argue in light of Uganda's international obligations, because everything we do, we have to align it in terms of the obligations that we have internationally. Uganda definitely is a signatory to various international human rights treaties, including, for example, treaties like the International Covenant on Civil and Political Rights. Yes? What they call the ICCPR. That is important for us to comprehend again from the word go. And also, if you look at it in light of the African Charter on Human and People's Rights, what they call the ACHPR, also that plays out in light of Uganda's obligation as a binding over, because we are signatories to these instruments. And if you're to argue in light of Article 8, particularly of the ICCPR, it prohibits forced labor unless it falls within permissible military service requirements. So Uganda's blanket classification of all retired soldiers as reservists without an opt-out clause would actually be seen as compulsory military service beyond active duty, potentially violating Uganda's international commitments. To defend now, or are we together in light of that? Additionally, General Comment number 8 of 1982 by the UN Human Rights Committee clarifies that reserve obligations must be clearly defined and time-bound to align with human rights principles. Uganda's law lacks specific regarding duration of service, recall limitations, and the right of reservists, creating potential for abuse. Substantive, important for you to comprehend where we are coming from. So, my friends, let's argue in light of the comparative jurisprudence, in light of the comparative analysis. Comparative look, for example, in terms of other jurisdictions, reveal more structured approaches to these so-called reserve force obligations. I'll mention an example. Let's argue in light of United Kingdom, what they call the Reserve Forces Act of 1996. The UK, for example, allows ex-soldiers to join reserves voluntarily with clear service durations and opt-out provision. So this prevents what they call indefinite military obligations and respects individual freedoms. Okay? Let me give another example. If you argue in light of the United States, what they call the Selective Service Act of 1980. In the US, for example, reservists sign contracts specifying services in terms of obligations, and they are not automatically conscripted post-retirement. So this model offers greater legal clarity and voluntary engagement. Let's be clear on that. On the other hand, Uganda's approach, by contrast, lacks voluntary consent and procedure safeguard, making it ripe for constitutional challenges. Are we together? Now, the point I'm trying to make here is trying to, first of all, find whether Dr. KIIZA BESIGYE and any other soldier for that purpose who's retired is caught between a hard place and a rock. And in light of substantive recommendations that I would perhaps look at in light of what I've just been talking about, I would argue and say Uganda's approach to reserve forces, as outlined in Section 42, subsection 1 of the UPDF Act, is legally and constitutionally problematic due to a number of factors. And some of them would be in light of ambiguity in civilian versus military status, and also in light of potential violation of constitutional rights, in light of forced labor and freedom of association. Yes? And then the point here also is that non-compliance with international human rights obligation creates another challenge in light of that. And that is something again you must comprehend even as you're trying to contextualize the argument that we're talking about today. In effect, it lacks what they call a lack of opt-out provisions. So unlike global best practices. Now, if I were you, which I am not, I would argue in light of some substantive recommendations that would perhaps try to create consensus in light of what we're talking about. I would argue in terms of aligning with constitutional and international standards that Uganda should actually do. I would argue in light of amending the UPDF Act to introduce voluntary enlistment in reserve post-retirement. That will become substantially important. I would argue in light of perhaps defining clear recall procedures, including time-bound obligations and an opt-out mechanism, because then it would leverage and give us the freedom of compulsory forced labor, and then I would also ensure civilian jurisdiction for retired personnel, preventing undue military prosecution. And that is something that you have to debate heavily upon. Yes? And then I would also think of perhaps aligning military laws with Uganda's international treaty obligations on human rights and even labor laws to try to harmonize some of these fundamental aspects in light of what I've just talked about. Okay? And then I would also argue in terms of following global best practices such as UK's voluntary reserve model to enhance fairness and even legal clarity. That becomes substantially important in terms of the things that perhaps would create better benchmarks for our country in light of true constitutionalism when it comes to serving or non-serving military personnel. So by implementing these reforms, I could argue that Uganda should be able to balance national security interest with individual rights, ensuring a constitutionally sound and jurisprudentially robust reserve force system. Super, super important. Yes? Now, because of the importance and the depth of the discussion that we're talking about today, I would like to delve a little bit deeper in terms of analytical jurisprudential considerations in terms of these so-called reserve forces in Uganda. Now, clearly, beyond the structural issues defined in the discussion that is just propounded, I could argue in light of constitutional and comparative international perspectives that warranty examination. And these perspectives assess the efficacy in terms of potential for legal abuse and the necessity to reform, especially Section 42, subsection 1 of the PDF Act. That becomes important. And one of the things I'd want to look at, or perhaps argue for the purpose of our discussion, is the doctrine of voluntariness versus compulsory military obligation. That becomes important. So one of the cardinal principles of military service under both Ugandan and international law is that military obligation should be voluntary and limited in duration unless mandated by exigent circumstances, for example, war or even national emergency. Super, super important. And then I will also look at the aspect of constitutional perspective, the argument of a right to free association. Yeah? And in this, I would probably provoke Article 29, Sub-Article 1E of the Constitution of Uganda, which guarantees freedom of association, including the right not to be forced into a group or organization. Fundamentally important. When you look at Section 42, Subsection 1 of the PDF Act, it appears to contradict this provision as it does not require the explicit consent of retired personnel to retain military obligations. Yes? And therefore, the doctrine of voluntariness is actually upheld in various Ugandan labor law precedents. So where courts have actually ruled against coercive employment relationships, look at the case of Paul Kafere versus Attorney General. which was, I think, 2014 case. It also brings up that component in light of that. Yes? And these are things that we're talking about in terms of trying to decipher or comprehend the discussion. So much important discussion today. And then we could argue in terms of the legal distinction between military conscription and voluntary service. Yeah? Uganda's approach can actually be likened to a form of conscription, as retired soldiers are automatically enlisted into the reserve forces. I would be quick to add that, however, under Article 17, Sub-Article 1J of the Constitution requires citizens to defend Uganda, but does not specifically specify a lifetime obligation for ex-military personnel. And that is something you must understand. When you look at Section 43 of the EPD Act, it allows for the President, for example, to recall reservists at any time, effectively creating an indefinite military obligation, which could be challenged as unconstitutional, regardless of your patriotism. The law is the law, and it's a question of now following the law. And if you're to argue in terms of substantive judicial problems that are likely to ensue out of the discussion, I could argue and say, does, for example, a soldier, upon retirement, retain an implied contractual duty of service? Ugandan contract law principles are seen, for example, in the case of Bank of Uganda versus Fred William Masabe, which was a 1999 case, emphasizes that obligations must be explicitly agreed upon without explicit post-retirement consent. Continued military obligations could actually be seen as unconstitutional in terms of an extension of service. And that is something you must comprehend again from the word go. If we're to argue in terms of what they call jurisdictional conflicts in light of civil versus military law, I would pose certain substantive questions. The question of court-martial jurisdiction, for example. Yes, one of the greatest ambiguities in Uganda's reserve forces system is the unclear jurisdictional status of reservists regarding military discipline and prostitution, for example. And this is what I'm talking about. Is Dr. KIIZA caught between the helpless and the law? When you argue in light of Article 126.1 of the Constitution, vests judicial power in the civilian courts. And that's what the Supreme Court argued, if you remember. However, if you look at Section 1191G of the UPD Act, it grants court-martial jurisdiction over any person subject to military rule, which arguably include reservists. Food for thought, not so? Food for thought. I am now beginning to open many of your eyes in light of intellectual, acumen here, not so? Now, the legal issue that this raises that if, for example, a retired soldier commits an offense, can they be tried by a military court? Yes? If you argue in light of Uganda versus Lieutenant Colonel retired Samson Mande case, suggested that military jurisdiction only applies for offenses committed while in active service, but did not conclusively address offenses committed while in reserve forces. Are we together? So let's look at the case of Adonai General versus Tumukonde. You remember that case? Made a lot of jurisprudence in light of that. The Supreme Court ruled that military law should not be used to unduly restrict civilian rights. This ruling suggests that reservists as civilians should not be subjected to court-martial prosecution for post-retirement conduct. A little bit of, salvage there, not so. And so as I argue these cases, I have to make substantive recommendation. My opinion would be that the law should explicitly clarify that reservists are subject only to civilian jurisdiction unless actively recalled to military service. That is super important. Now, let's talk about the aspect of legal precedents on forced military obligations in terms of international law. Those are some of the things that you may want to argue in light of what I'm talking about today. Listen, Uganda's approach, in my opinion, must also be examined against global legal precedents, particularly where courts have ruled against compulsory military obligations in light of post-retirement. That is super important. Yes? If you look at the European Court on Human Rights, what they call the ECHR precedents, particularly the case of Matthews versus United Kingdom, which was in 1990, the ECHR ruled that indefinite reserve obligations without explicit consent violated the European Convention on Human Rights, the ECHR, particularly Article 4, which prohibits forced labor. Yes? When you look at UK versus Turkey, which is 2006, it ruled against lifetime military obligations, reinforcing that reservist systems must be voluntary and clearly defined. Are we together? Now, let us bring it a little bit in terms of the African context. The African Court on Human and People's Rights, what they call the ACHPR, has also got its own say. We are sure and we are aware that Uganda is bound by the African Charter on Human and People's Rights, the ACHPR, which prohibits involuntary military service outside clear legal provisions. Yes? When you argue in light of Article 6 of the ACHPR, guarantees freedom from arbitrary detention, which could be violated if reservists are detained for refusing to serve after retirement. Important aspect. So, in Committee Interafricains des Femmes versus Burkina Faso, which was 2011, the court ruled that laws imposing involuntary obligation post-employment were unconstitutional under the ACHPR. Yes? So, what are some of the legal risks that Uganda may have in light of that? Let's analyze that. Uganda's system, by failing to clearly define the nature, duration, and voluntariness of reserve obligations, could actually be challenged before the East African Court of Justice, okay, or the ACHPR as a violation of fundamental rights. Not so. Let's argue in light of comparative analysis of reserve forces systems in other countries, for example, because that will give us a benchmark so that we know the strength and the weaknesses. The argument here is that Uganda's compulsory reserve membership model contrasts with more flexible international systems. Yes? And in doing so, there are certain legal implications that Uganda has to ensue. Uganda, for example, lacks explicit time limitations on reserve forces obligations, and that becomes a serious problem for us. Number two, there is no formal consent mechanism, unlike in devolved legal systems. Then that becomes substantially important in terms of jurisprudence. Uganda could also modernize its laws by adapting what they call a contract-based reserve system, allowing retired soldiers to opt in rather than be automatically conscripted. That would also suffice in light of what we're talking about. Then we could also argue in terms of policy and legal recommendations, in terms of reform, for example. What are we looking at? What are we looking at? We could argue, given the identified constitutional jurisdiction and international law concerns, Uganda must revise its legal framework governing the reserve forces. Not so. Now, the argument here being is that no doubt that there should be an amendment in light of Section 42, Subsection 1 of the PDF Act to introduce an opt-in mechanism for reservists, ensuring voluntariness. Okay? Now, specific duration of service, for example, a 10-year reserve period post-retirement, could also be another option, because these then create some kind of voluntarism and without undue coercion or force. Not so. Now, we could also argue in terms of limiting military jurisdiction over reservists. Yes? So the amendment of, for example, Section 119, subsection 1G, to clarify that retired soldiers are subject to civilian courts only unless formally recalled, becomes a question of importance. And then the aspect of aligning with Uganda's international obligation is also something you cannot run away, because as we said, whatever affects us substantially affects another country. Uganda should revise its military laws to comply with the SCHPR, the ICCPR, and the ECHR standards, ensuring freedom from indefinite military obligations. That, my friend, becomes substantially important. You've heard of that saying, retired, but not tired. You see this guy is coming up, not so. Now, we could also introduce parliamentary oversights on recall decisions, for example. Yeah, currently, recall decisions are at the discretion of the president under Section 43 of the PDF Act. Okay? And the argument here being that a parliamentary review mechanism, for example, should be established to ensure transparency and prevent abuse. Because in doing that, then we are creating some kind of what? Some kind of fairness in the system that we're talking about. Now, it's easy for you to argue and say, what is this gentleman saying? But this is jurisprudence, and these are things that will catch up with us in one way or the other. And the earlier we contemplate about them and think about them, the better. So while Section 42, subsection 1 of the PD Act serves as the legitimate national security function, its indiscriminate and indefinite application, in my opinion, raises serious constitutional and human rights concerns. And the current automatic membership model, in my opinion, violates the principles of voluntariness and the freedom of association under the 1995 Constitution and Uganda's international commitments. So to me, I think those are some things that we need to think about deeply. Also, important to note, the jurisdictional ambiguity concerning court-martial trials for reservists further undermines this aspect of the rule of law. Yeah? As I said, comparative legal analysis suggests that Uganda should actually modernize its reserve force systems by introducing clear time-bound obligations with voluntary enlistment mechanism. Now, these are things that, in my opinion, the ordinary man may not really contemplate, but our brothers and sisters who are in uniform or who have retired undergo a lot of pressure in light of these things, and that's why I'm laboring to shed some light. So by implementing these legal policy reforms, Uganda can actually ensure a constitutionally sound and internationally compliant and practically effective reserve forces system. Some of you are probably aware that we've come up with a book called Legal Trigger, that one that we wrote with retired, I'll use the word retired, advocate of the High Court, Tengo Luogo, and myself, called the Legal Trigger. Find that at luogo.org. But we could also argue in terms of broader constitutional and human rights implication in terms of reserve, Uganda's reserve force systems as well. So, while I have actually labeled to focus on jurisprudential and even comparative legal analysis, I could also delve deeper in terms of constitutional and human rights implications. Yes, in terms of Uganda's automatic reserve enlistment model that raises questions about individual rights and separation of powers and the potential for a state overreach. And this is something that African countries, in my opinion, have to take extremely serious. Because we so much rely on the gun, the will of the gun, not so, and the army and stuff like that. Yeah. So constitutional tensions in terms of the right to liberty versus state security interest, for example. Yeah. The 1995 Constitution of Uganda enshrined several rights to appear to be in tension with Section 42, subsection 1 of the PD Act. Yeah. And that is something, again, we just can't run away from. Yeah. And in doing that, it poses substantive legal challenges in terms of risks. Yeah, a retired shoulder, in my opinion, could actually file a constitutional petition challenging reserve membership under Article 137 of the Constitution in terms of constitutional or interpretation. Yeah, so that they can have enlightenment in light of that particular aspect. And if you argue in light of Dr. KIIZA BESIGYE, for example, versus Attorney General, the Supreme Court ruled that national security cannot automatically override fundamental rights, suggesting potential legal challenges to indefinite reserve enlistment. And these are questions again that have to be addressed, in my opinion. Okay, because then if we don't do that, as I said, they'll still come back and knock at our door tomorrow. And in doing so, I would argue and make substantive recommendations in light of the discussion that I'm having with you today, that the UPDF should actually be amended, in my opinion, to align with constitutional protection by making reserve enlistment, for example, voluntarily or even subject to time limitations. Yeah, and that would probably remove all those challenges that are substantially likely to come at a certain time T. Yes, and then I could also argue in light of political manipulation and the militarization of civilians, the potential for political manipulation and militarization of civilians, which is a big substantively a big problem. Uganda's political history obviously raised concerns about how mandatory reserve forces membership could actually be misused for political ends, and that is something that you should also think about substantively as food for thought. Yeah, we cannot rule away from the fact that our historical context, Uganda has a history of military influence in terms of politics, from the likes of Idi Amin in terms of dictatorship, to the NRM continued reliance on military structures for governance, and that is something again that you may want to think about in light of our discussion today. So the question here again poses the risk of political deployment. Automatic reserve enlistment could actually be exploited to deploy retired officers for political purposes, no doubt, including suppressing political dissent, for example. Haven't we seen some of these things in this country? Without even mentioning names, haven't we seen some of the things in this country? Even being pointed to political positions because of that. How about aspects of influencing elections, for example, through intimidation, even strategic mobilization? Yeah, we all know certain people who retired long time ago, and quote unquote, they are probably the people who govern certain substantive sections in this country. Not so. How about expanding executive control over civilian affairs under the guise of national security? Yeah, all those things are things that are food for thought that we need to think about deeply without even really debating much. So these are things that this topic becomes substantially important in light of the future. We're looking at one thing today, but it has far-reaching consequences. I could argue in terms of the role of retired officers in political conflicts, for example. In 2001 and 2006, for example, in terms of Uganda elections, we saw increased militarization with the deployment of veterans and even reservists in election-related security operations, for example. Yeah, remember? And then the aspects of, if you look at, for example, the case of Brigadier Henry Tumukunde of 2005, which illustrated how retired officers remain under state control, raising concerns about reserve enlistment being a tool for political control. And these are things that we are arguing today that we need to contextualize in light of the future. We cannot run away from these things. And then the argument in terms of comprehensions, perhaps by way of comparative analysis, if you could draw an international parallel, for example, in Zimbabwe's national service law similarly requires former military personnel to serve indefinitely. Yeah, and in doing so, it has actually created this system has actually been widely criticized for being used to recruit former officers into political repression units under the so-called ruling party. And these are things that again that we're talking about in terms of substantive challenges that we may have. Okay, if we don't address these issues, we're in serious trouble. So the point here is that Uganda risks falling into similar patterns unless reserve enlistment is actually made transparent and politically neutral. And that is something that you must think about deeply as a country. And another thing that maybe comes to mind in light of substantive way forward by way of recommendations is Uganda should actually establish what they call independent oversight over reserve recall processes, for example, involving parliament or even judiciary to prevent political misuse. This becomes substantially important. I think I'm dreaming of a country where we are not a military junta, but we're a constitutional democracy, where the three arms of government can operate independently without any fear or favor. If we argue in terms of economic and even socio-economic consequences for lifetime reserve obligations, for example, the impact of employment and civilian careers, for example, these are questions that can be debated. Yeah, retired soldiers transitions into civilian professions, yes, but indefinite military, obligations create legal and even logistical obstacles for them, and that becomes, a dilemma in one or the other. Internationally, for example, employment, some countries require proof of military exemption if they're to give you certain jobs, for example. Yeah, and then the argument of private sector security, employers may actually avoid hiring individuals subject to recall, because they are not sure at what time these individuals will turn into the other individuals, as you know. So the aspect of political or even diplomatic appointments, for example, as reservists may actually be perceived as agents of the state. I mean, don't we see these things? Am I really making up these things for myself without even mentioning names, in all honesty? Aren't we seeing the things that happen, or am I just making statements that are substantially not true? Yeah. How about aspects in light of comparative analysis? You could argue in terms of the US and the UK models, for example. Yes, the United States, for example, reservists, sign contracts defining what they call service duration. Yeah, ensuring predictability, for example, for employers. And I mean, you could argue also in light of the UK in terms of the Military Reserve Policy Act that allows reservists to refuse service under exceptional circumstances, for example, under job conflicts and even health. These are issues that we should contemplate and think about substantially. So the argument here is that Uganda lacks similar protection, and therefore placing retired officers in legal limbo between military and civilian obligations. And perhaps this is where many are taken advantage of because of that weakness in light of the law. And that creates, as I said, a substantive legal challenge as a risk for our brothers and sisters and even for the country. So the point is that a retired soldier denied employment due to uncertain military obligation could actually sue under Article 40, Article 1B of the Constitution in light of right to work, for example. Yes? And then, if you look at the case of, I think what it was, Mpanga versus Attorney General, which established the argument of the state-imposed restrictions on employment, which must actually be proportional, meaning Uganda Reserve enlistment could actually be challenged for violating labor rights. And that is something, again, that we need to take away as food for thought. These are substantively important aspects, my friends. For those of you who believe in constitutionalism and the rule of the law, and are passionate about our country being a democratic society, I think this is some serious food of thought. And the point here is that Uganda should define clear term, limits for reserve. For example, maybe a 10-year post-retirement. Maybe introduce legal safeguards for employment rights, for example, similar to the US and UK models as examples. So that we can borrow from some of those countries, so that we can enhance and create a system that is equitable for all of us to enjoy without abusing or taking advantage of any other individual. Yeah, and then we could also argue in light of the potential for human rights violations when it comes to reserve collapse. That becomes again another substantially important aspect for us to argue. Yeah, you could look at what we call forced mobilization risks, which becomes another big challenge in light of the dispensation of the discussion that we're having today. Uganda, no doubt, has a history of controversial military mobilization practices. Yeah, including things like the forcible conscription of youth in the 1980s, such as Bush War. You remember some of those things. Yeah, I don't want to mention the name, but you know what I'm talking about, the Kadogo likes and the likes, and then the aspect of allegations of forced military recruitment in Karamoja, for example, documented by Amnesty International, and all these things are researchable and found in research centers. So some of these things create substantive debates, intellectual debates in light of what we're discussing today. So in my opinion, the absence of judicial oversight in reserve enlistment could actually lead to arbitrary mobilization or violating international human rights law and causing substantive challenges for us as a nation. And these are things, again, as I say, that is substantive food for thought that we need to think about explicitly. Yeah? And then we cannot underestimate, I'll say this on and on again, Uganda's international legal obligation, because whatever we do, as I said here, affects one way or the other our neighbors or any other person in that effect. Uganda is bound, no doubt, by International Covenant on Civil and Political Rights, what they call the ICCPR, particularly Article 8, that prohibits forced labor, including non-consensual military service. That is something that you must understand from the word go, and substantially important for us as a country, and even as a nation in light of some of those rights. And then if you argue in light of the African Charter on Human Rights and People's Rights under Article 6, for example, it protects against arbitrary military obligation, which again also is substantially important in light of that. If you have not been in that uniform, I've seen people struggle trying to get out, especially those who have a semblance of authority and are likely to affect the masses. They're held up as hostage in one or the other. But also, if you look at the East African Community Treaty that requires non-discriminatory military service policies among member states, that also, could actually be invoked in light of the discussion that we're having today. So these are fundamentally important aspects in terms of arguing what could and could not be in light of addressing some of the challenges that I'm talking about today. Now, I shouldn't forget, obviously, I may have talked about it, but as a legal challenge, by way of a risk, Uganda's compulsory reserve model could actually be challenged by the East African Court of Justice. Precedents such as the Tanganyika Law Society versus Tanzania, which is 2013, suggests that military policies violating regional treaties can actually be struck down. And that is something that's food for thought, and you have to keep in mind in light of that. Not so. And then you could also argue, by way of a recommendation in light of that particular aspect, how do we address this challenge? How do we, find solutions to some of these challenges? Uganda, in my opinion, should introduce judicial review mechanism to ensure due process before recalling reservists, for example. And that is perhaps something that is food for thought for those of you who are in the system and are likely to pick a leaf here and there. And the amendment of the EPDF Act, as I said, to explicitly remedy military collapse to define national emergencies is something that also we should think about. And then a call for comprehensive legal reform is no doubt, in my opinion, a very fundamental aspect. Uganda Reserve Force system as structured under Section 42, subsection 1 of the EPDF is, in my opinion, constitutionally problematic and vulnerable to political misuse and out of step with international best practices. And these are things that perhaps we should think about in light of creating a future for our country. In terms of key legal and even policy failures that you may identify in light of some of the things, you could argue in light of violations in terms of the right to free association, particularly Article 29 of the Constitution. That is something that you may want to think about. You may also want to look at aspects that have to do with the issue of lack of clear jurisdictional boundaries in light of military versus civilian legal oversight as another substantive legal challenge, and these are fundamentally important in terms of the things that we are talking about today. As I said, the discussion today is not for the faint-hearted. It's serious business. It is serious business. And then the aspect of creating what they call economic and employment uncertainty for retired officers. This is also something maybe we could also think about in light of the discussion we're having today. And then the aspect of opening the door to political militarization and even human rights abuses should also be looked at as another potential upside if you are not careful in terms of trying to resolve some of these challenges. And then of course aspects to do with contradictions in light of Uganda's international legal commitments under the ICC PR or the ICHPR or the East African, African community laws as well. So these are fundamentally important aspects that we need to align ourselves so that we are seen as a nation that not only says the talk but walks the talk as well, not so. So, in my opinion, the amendment of Section 42, subsection 1 BDR to make reservist enlistment voluntary, it should be substantively extremely important in light of the challenge that we're having today in this country. And then the aspect of limiting reserve obligations to a fixed duration, for example, in my opinion, we argue in terms of maybe a 10-year post-retirement is also fundamentally important. These are substantive takeaways because I know there have been substantive arguments by the distinguished honorable justices of the Supreme Court in light of certain amendments that have been called for in light of the UPDF Act. Perhaps these are some of the things that we could also look at. And then in terms of defining clear jurisdictional rules, ensuring retired officers are tried only in civilian courts, as the case of Dr. KIIZA BESIGYE perhaps. And then introducing employment protection for reservists to prevent job discrimination as well becomes fundamentally important in light of the discussion that we're having today. And of course, we could also argue in terms of establishing independent oversight for reserve call-ups, to prevent political misuse. Because if we don't do that, then we are creating a junta state, or what they call a deep state, in light of some of these challenges, which we don't want to see in a country like ours, which is beginning to blossom in light of the future, in spite of the challenges that we're having today. So by implementing these critical reforms, my argument would be that Uganda can actually have what they call a balanced national security interest with constitutional rights, ensuring military professionalism, and even, which His Excellency, by the way, is a drum major in saying military professionalism, and also preventing potential legal challenges that domestically and internationally could affect our country. Not so. And these are things that, in my opinion, would be fundamentally important in terms of food for thought for His Excellency and the powers that be. Not so. And the powers that be. In terms of substantive takeaways, the imperative for legal and policy reforms in Uganda Reserve Forces as a framework should actually be substantively evaluated. The legal framework governing reserve military services in Uganda, as codified in Section 42, subsection 1 of the PUD Act, presents serious constitutional, human rights, and even international concerns, while the provision serves to legitimate national security interests by ensuring a trained military reserve force. Its automatic and indefinite enlistment model raises substantial legal and even policy challenges and cannot be ignored. And that is, in my opinion, a very, very, very important aspect. So the critical and holistic analysis of Uganda's reserve forces system reveals fundamental contradictions in law, in practice, and as far as policy is concerned, which basically undermine the constitutional rights of retired soldiers and creates economic and even social uncertainties, and open the door to political manipulation and even right violations. And these are the things that we don't want to see. If someone has been a serving, soldier for some time, they're quite incredible people. We know, you and I know. I mean, let's give them the honor. They are our veterans. They are heroes in one or the other. They should be honored with that respect rather than humiliating them. Yeah. In terms of key legal and policy failures that have been identified, as I said, and constitutional compulsory reserve membership, automatic enlistment that violates Article 29, Subarticle 1E of the Constitution, which guarantees the right not to belong to an organization. And these are things that I'm drumming over and over and over and over, so that you understand the power, the challenge that we're having. And obviously, I would argue that you remember the case of KIIZA versus the Attorney General, which affirms that national security cannot automatically override fundamental rights without justifiable legal safeguards. These are things that we should be drummed in our ears, and so that we can live with them and also act on them, and they become part and parcel of the life that we are living in today. And the ambiguity in light of jurisdiction and legal protections, for example, also is another aspect that we need to comprehend. Retired soldiers exist in a legal limbo, in my opinion. They are considered civilians, yet remain subject to potential military recall, and that puts them in that dicey position. Yeah, and we should free them if we have to, in terms of the law. And I just mentioned the case of Uganda versus Lieutenant Colonel retired Samson Mande, where the High Court ruled that military jurisdiction ceases upon retirement, but this conflicts with the Patriot Act provisions on reserve duties. And that is perhaps the dilemma that I see in the issue of Dr. KIIZA BESIGYE being between a hard place and a rock. And these are the challenges that I'm going to propound. Leave alone people like Aaron KIIZA, who are not substantially soldiers or former soldiers, but people like Dr. KIIZA BESIGYE and the likes, who have been substantially soldiers. So we need to look at that. And then in terms of economic and social disruptions, indefinite reserve obligations create these legal uncertainties for employment and business opportunities and even international travel. Yeah, and these are some things also we need to talk about in terms of food for thought. You need to be in these people's feet and walk their path and understand the pain and the troubles that they go through. I may have had a little bit interaction with some of them, and I know the challenges that they may have. But I just told you in light of Mpanga versus in general, that rule that self-imposed restrictions on employment must actually be proportionate, making Uganda compulsory reserve, a model ripe for legal challenge. And that is something that is substantially important again in terms of a takeaway, so that you know that, listen, we are here, we are moving, but there are substantive things that we need to think about. Perhaps it's time the Attorney General and the group to hire substantive, brilliant, intelligent, sui generis lawyers who can be able to analyze and think through some of these things. The risk of political arbitrage, for example, historical misuse of retired officers for political purposes suggests that compulsory enlistment can actually be weaponized for political mobilization. Suppression of dissent and election of manipulation. And no one can deny that these things are not happening. I just mentioned the case of Brigadier Henry Mkunde, for example, that illustrated how retired officers remain under state control, posing risk of political militarization. So these are things that you and I are observing, and I know that our brothers and sisters in the army are looking at them, and they are having pain in light of how to free themselves from some of these things. And in doing so, where my argument is to prevent violations of Uganda's international obligations, in light of forced military recall, which violates Uganda's commitment under certain international obligations, as I mentioned, the International Covenant, for example, of civil and political rights, and basically Article 8, prohibition of forced labor. These are substantially important aspects that we need to look at. Look at the African Charter on Human Rights and People's Rights under particular Article 6, that protection against arbitrary military service, for example. All these things are not coming from the sky. These are substantially provisions that are in the law, and it's high time that Uganda takes serious concerns over them. The East African Community Treaty requirement for non-discriminatory military service policies also becomes a question of debate. So these are things that you cannot hide away. As a country, we need to understand and comprehend in terms of what has to do. We cannot rule away that the East African Court of Justice, for example, has ruled against states whose military policies violate human rights. Look at Tanganyika Law Society versus Tanzania, which is 2013. Meaning that Uganda's system is at risk of legal challenge at regional level as well. So these are things that I'm just trying to be a drum major and kind of opening your eyes so that you can see where we are going in light of some of these challenges. So the debacle or the challenge that whether or not Dr. KIIZA BESIGYE is between a hard place and a rock is the cause of this debate. And is the cause of why we need urgent legal and policy reforms. And I'm not being political in any way. I'm just being constitutional. I'm just trying to be scholarly in terms of opening up eyes. We need to align our reserve system with constitutional, human rights, and international law standards immediately, so that these reforms become necessary, and government, as I said, should move super fast to amend Section 42, Subsection 1 of the EPA Act, so that you can align itself with right law. As I said, shift from compulsory to voluntary reserve enlistment. After a specified period, for example, that are suggested, maybe 10 years post-retirement. In light of those, then we can have we may have to reduce on some of these charges. So we should allow these officers to opt out of reserve obligation through a legal process, for example, so that we don't put them between a hard place and a rock. And these are substantially important arguments. As I said, I could go on and on and on and on, but because of time, I think I have made fundamental almost everything in terms of clear jurisdiction boundaries, in terms of international standards, in terms of benchmarking, in terms of defining military versus civilian legal status, in terms of reservists, in terms of explicitity of the law. So I have made my points in light of that. But I would like to thank you for your attention. Many of the things are written. This is not in this one, but many other books. But this is one of the books that we have at global.org and Sue Generis Law App. And some of the people who have inspired us in terms of constitutional law in this country, the likes of Professor Oloko Nyango, the likes of Dr. Henry Honoria, the likes of Dr. Kawumba, the likes of Dr. Reheza, the likes of Dr. Zahara, the likes of Professor Mazira, the likes of Dr. Naruwairo, name them. I could go on and on and on. All these have been an inspiration in terms of what to do. And I'm not saying this because many of them may sound what? may sound what? May sound they may not align in certain political whatevers, but the argument is jurisprudence in the making. They provoke our thoughts. But I would like to pay a special thanks to my friend Professor Ben Tuinomugisha, who he said that behind every script there is a face. So the argument here, introducing perhaps as a takeaway, we will introduce a reserve status certificate to clarify individuals' military status for employment and even international travel purposes, for example, as a takeaway. And that would perhaps augur very well. And some of the talks that I give come particularly because of my discussions with some of these incredible, gifted, brilliant professors from all over the world who we engage in, and sometimes they pose questions and I'm like, wait a minute, I think that is food for thought. Yeah, so I have basically addressed many of these major issues. And once again, my name is Isaac Christopher Lubogo. Find many of our books at lubogo.org and SueGenerisLawApp.com. Thank you and God bless you. I have done this purposely to provoke thought without any malice of forethought. Thank you, and thank you once again.